From the American Bar Association Law Museum in Chicago, the section of Antitrust Law presents the Oral History Project. Interviews with the leaders who have made significant contributions to antitrust law practice.
Good afternoon. My name is Robert Joseph. I'm a partner with the Chicago office of Sonnenschein, Nath, and Rosenthal, LLP. Today we have the pleasure of visiting with Judge Richard A. Posner, a member of the United States Court of Appeals for the Seventh Circuit. Few lawyers have affected an area of law as Judge Posner has influenced antitrust. A 1959 graduate of Yale College, he received his law degree from Harvard Law School in 1962. After serving as president of the Harvard Law Review and clerking for Justice William Brennan, he has utilized every position he held in government and academia to reshape antitrust doctrine as we know it today. Since 1981, Judge Posner has served on the Seventh Circuit Court of Appeals in Chicago, where he has had further opportunities to directly influence antitrust law through his decisions. From 1993 to 2000, he was Chief Judge of the Seventh Circuit. He currently is also a senior lecturer at the University of Chicago Law School. Judge Posner, good afternoon. Let me start by asking you, when and how did you become interested in antitrust law and policy?
I was a second-year student at Harvard Law School. I was on the Law Review. And a young professor, Derek Bach, later the dean at Harvard and then president of the university, had submitted an article to the Law Review called Section 7 and the Merging of Law and Economics. And the Law Review editors gave me, just by accident, they gave me the section of the article in which he discussed the economics of oligopoly. And I didn't know anything about economics. I hadn't studied economics in college, didn't know anything about antitrust. But I thought it was quite interesting, these diagrams that illustrated oligopoly problems. So it was very, very interesting. And I was also friendly with Don Turner, a professor there, who was an economist, had a PhD from Harvard. And then I took the antitrust course my last year with Phil Arita, who I think was only his first or second year, or early in his career. He later became a very successful teacher and a very prominent antitrust scholar, but at the time I found his course really dull. But then I went and clerked, as you said, for Justice Brennan, and again, I assume it was just a coincidence. Having been assigned a merger case, United States versus Philadelphia National Bank, he asked me to work on it. And of course, since it was a merger case, I remembered Bach's article, which had now been published. And in particular, he had emphasized the importance of having simple rules of antitrust. And the year before, the year I clerked with Brennan, the Supreme Court had had a merger case called Brown Shoe, in which the judge, nominally Chief Justice Warren, actually his law clerk, had written a meandering opinion. Obviously, he had no feel for antitrust, and it was very vague, and was actually, although it was a very kind of left-wing opinion, because Brown Shoe had a tiny market share, there was so much junk in there that the defense bar actually picked up and used Brown Shoe quite effectively. As a lawyer, a very successful lawyer and professor in New York, Milton Handler, who read Brown Shoe very carefully and mined it for all its conservative implications, accidental as they were. But Philadelphia Bank, partly I say with the recollection of Bach's article, I thought we should, have a simple prima facie case of violation, and so that's what the Supreme Court agreed to, and so I found that very interesting, and And in the spring of that year, I'd been clerking for Brennan, I actually had accepted an offer at a New York law firm, Paul Weiss. But then the fellow working for Phil Ellman, FTC commissioner, called me up and said he'd really enjoyed the job, and would I like the job? And I went and talked to Ellman. I was very impressed. He's very smart. So I reneged on Paul Weiss, who sent me a rather curt letter saying, good luck with your career in government, as if to say, never get out of government now, having broken my contract. So Ellman was very good, and the Federal Trade Commission had some very interesting antitrust cases that I worked on, like Procter & Gamble's acquisition of Clorox and a number of other fun cases. And I went to work for the Solicitor General, and I was interested particularly in antitrust and public utility regulation, common carrier regulation. So I worked on those cases, and I say Don Turner was now the head of the antitrust division, and I'd been quite friendly with him at Harvard. And so I particularly worked on antitrust. I mean, I worked on a lot of other cases too. I worked particularly on antitrust. I was particularly interested in that. And I argued two cases, the Vons grocery case, a merger case, and the Schwinn case, which was a restricted distribution case. And that was fun. Now, in retrospect, I don't agree with the position we took. And in fact, Schwinn was in fact overruled in the Sylvania case in the 70s. And Vons, I don't think it's ever been expressly overruled, but certainly abandoned.
At the time that you argued those two cases, did you have any misgivings about the government's position?
No, I didn't have any. Partly didn't have misgivings because if you're a lawyer, you do what your client wants, and Turner was basically my client. Now he recognized that the Vons case was really marginal because it was a merger of two small grocery chains in Los Angeles. They had like an aggregate market share of maybe 8% or something. And of course, there's very easy entry into the grocery industry. He was very concerned about the ease of entry. I mean, he was a very intelligent person. Now, it was a different world of antitrust thinking. So I hadn't, in my FTC experience or as a law clerk or working in the Solicitor General's office, I hadn't come across any of the Chicago school type stuff. I just knew the sort of Harvard school of workable competition, people like Edward, I think it was Edward Mason, and Bain and Chamberlain and Fellner, although Fellner was really sharp. So I actually tried, when I was in the SG's office, I tried to read George Stigler's price theory book, which is a very good textbook, intermediate price theory, but it was too difficult for me, so I never got there. So my views of antitrust were very conventional for the 60s. Then, of course, changed when I went to Stanford. But
I'd like to circle back for a moment to the Philadelphia National Bank case and ask you whether you think the Philadelphia National Bank presumption still holds up today. Do you think that the current 1992 version of the federal agency's horizontal merger guidelines weaken that presumption in favor of a number of industry-specific and market-specific factors that may predispose a market to or against the forms of collusion that are difficult to detect, including tacit collusion?
Oh, yeah. No, in Philadelphia, you're talking about 1963. So, that's 45 years ago. So I think it was Turner who started in with merger guidelines. And they've evolved, and they're very sophisticated. I have some criticisms of some of them, but they're really good. And oh, sure, they're much more sophisticated thinking about antitrust, and also more conservative policies and judges and so on. So no, I wouldn't. No, I think what was good about Philadelphia Bank was recognition that this area really had to be governed by guidelines. You couldn't have you couldn't have an approach which said, well, we're just going to look at all the relevant circumstances. That was formless, provided no guidance. And of course, in a merger situation, firms really need advanced guidance. They don't want to merge and then be sued and broken up. So what evolved was merger guidelines by the Justice Department, by the Federal Trade Commission. So there are very few litigated litigated merger cases now. They're almost all resolved by negotiation with the enforcement agencies.
You referred to your time with Commissioner Philip Ellman. Could you please give us a picture of what the Federal Trade Commission was like at that time and what it was like working for the legendary Commissioner Ellman?
Well, the FTC was a terrible backwater agency. It had been started in 1915. It was ordained by the Federal Trade Commission Act 1914, passed at the same time as the Clayton Act. And it was part of the kind of progressive movement, the notion that administrative agencies could do things that courts couldn't do. And of course it was a flop. And by the 60s it was a real backwater. And then Ellman was appointed, he's very smart, graduate of the Harvard Law School, and he was sort of a career assistant to the Solicitor General. Very, very, very smart. He clerked for Frankfurter. And he was appointed by the Kennedy administration. And that was a breath of fresh air for the FTC. He was not popular with his colleagues, but he really did a lot for the FTC, and it was fun. He was a very, very good lawyer. And I really enjoyed working for him, learned a lot from him. And it wasn't all antitrust. You know, FTC had and has a consumer protection function, and one of the big projects I worked on for him was a report on cigarette advertising and labeling. This was in the 1964. The Surgeon General of the United States issued his report on cigarette smoking. And Ellman decided the FTC should jump in and regulate and, well, require warnings in advertising and labeling. It was very controversial, and I worked on that. And it eventually was superseded by Congress. First, Congress forbade the warning in advertising, but put in labeling. Eventually, of course, the rest is history.
How did you feel when Congress stepped in to take over? Or were you
well, I'd left by then. I don't remember having any reaction. So yes, Ellman was very good, and he had big impact. Unfortunately, so eventually he was reappointed, although there was opposition. He was reappointed by Johnson. And then he left, I guess, when Nixon became president or when his second term ran out. And although he was still young, I mean, in 50s, he went into practice, but he didn't like practice. He didn't really do much after that, which was unfortunate because he was extremely able.
You mentioned you worked on Robinson-Patman Act cases. Did your work when you were working on those cases at that time, did you already have problems with the Robinson-Patman Act as a statute at that time?
Oh, about the Robinson-Patman Act, yes. He was very skeptical of it, and the FTC had over-enforced it. So I did work for him on cases that I have thought about Robinson-Patman Act much, but I worked on cases for him that cut back on Robinson-Patman and also on some of the excesses of the Commission's consumer protection cases.
In 1969, shortly after leaving government service for teaching, you were appointed to the ABA Commission to study the Federal Trade Commission, also known as the Kilpatrick Commission, after Miles Kirkpatrick, its chairman, who was later chairman of the Federal Trade Commission itself. The report of the ABA Commission accepted that the FTC's basic design and mission were worthwhile, but it was very critical of managerial failures such as lack of planning, infighting among the commissioners, and the deficient quality of the agency's staff. Could you tell us about your participation on the ABA Commission and about the separate statement you prepared?
Well, I wasn't very impressed by the commission and by this, ABA thing. And Phil Ellman testified before our little committee, and he said he thought the FTC was hopeless and should be abolished. I agreed with that. I'd already, I'd started teaching. I'd been meeting these Chicago people, so I had become more skeptical. But I was wrong, because what I didn't realize, beginning with Kirkpatrick and continuing to this day, the FTC really turned the corner and changed dramatically, and has become a respectable enforcer of antitrust along with the Justice Department, and does a good job, pretty good job anyway, with consumer protection. So it was I gave a talk on
90th anniversary.
Yeah, I gave a talk in Washington, and and actually it's a version of it was published, and I said, yeah, I was wrong about that. Its defects, it turned out, were less in the design than in the execution, and that turned out to be correctable. Not that it's ever going to take the lead role in antitrust. It's not never going to be a major part of government, but it's respectable, which I wouldn't have expected in 1969.
You mentioned in 1967 and 68 you were general counsel to the President's Task Force on Communications. What was the charge given to the Task Force on Communications, and what was your role as general counsel? And can you tell us about the result of its work and the effects that its work has had?
Well, it ran from something like October '67 to, and I went off to teach in, probably I left in July, so it wasn't quite a year. And so it was, President Johnson loved creating task forces. So this was his task force on communications policy, and it was headed up by Eugene Rostow, who'd been dean of the Yale Law School and was the number 3 person in the State Department. I was told the fact that he'd been made head of this task force showed that he was actually a marginal figure in the administration, because it was considered unimportant. And he had a very good staff director, a fellow named Novak, Alan Novak, very, very smart. And I was called the general counsel, but Novak had a staff. I was one of, it was a very tiny staff. I don't know why they called me the general counsel, but it wasn't anything.
Does that mean you did a lot of the writing?
Well, I did the writing because that's what I like to do, but it didn't have anything to do with being called general counsel. And had a very good research director, Leland Johnson, very good economist from Rand. And I learned a lot of economics from him, which I hadn't really picked up. So that was fun. And the idea behind the task force was that there was pressure for opening up telecommunications to more competition. So AT&T had a real lock on telecommunications, and they had abused their power. So they wouldn't let anybody attach anything to the network that wasn't supplied by AT&T. And they wouldn't sell anything either, just rentals. So if you wanted a telephone, you got it from the phone company. It was their property. And some little company made something called a hushaphone, which was some little rubber contraption that you put on the speaker part of the phone to make it more difficult for people in the room to overhear what you were saying. And AT&T said that was forbidden. That was a foreign attachment. And that was so preposterous. And then people started to think, well, wait a second, what exactly is wrong with having an attachment made by someone else? Wouldn't that be good? You know, have create competition. And so that's what got this commission, or this task force going. And also, there's cable television was in its youth, and at the time, cable television was usually thought of as just a way of improving signal quality, you know, in mountainous areas. But some people were starting to say, no, it could greatly expand the number of channels and hence the amount of competition in the broadcast industry, which of course the networks were very hostile to. And then there was this upstart company, MCI, which wanted to compete with AT&T in long distance, and they started off by building microwave towers along railroad rights-of-way and offering the railroads, in effect, an internal telephone system. And then they wanted to go into competition with AT&T, which horrified AT&T. And again, there were people who said, you know, what's wrong with competition in long-distance service? So there was a ferment in '67, which led to this task force, and then we produced a report that submitted to the president in the fall of '68. Of course, the president now a lame duck, but the ideas in this, which were strongly pro-competitive, I think had an impact. And that impact, I think it was part of the reason, perhaps, that the Justice Department brought a lawsuit in the early '70s to break up AT&T. And the combination of the kind of competitive notions that had inspired our task force, combined with the AT&T lawsuit, began to really shake up the communications industry. And, you know, eventually, of course, I guess '81 or '82, AT&T was broken up. So, and then we realized that the monopoly had been a very bad thing, because AT&T had a completely screwed up rate structure in which very high rates on interstate service, long distance, were used to subsidize local service. So local service was underpriced, long distance overpriced. And when entry was allowed, the rate system altered, and it also turned out that business customers had long complained about AT&T, very unresponsive to customer needs. And as soon as it was possible to attach your own equipment, a whole industry grew up in providing equipment designed for business needs. So it was big. But I remember, so I was hired by AT&T as a consultant throughout that lawsuit until I became a judge, of course, and that was fun. But the attitudes from AT&T, they're so stupid. I remember, so the people at AT&T were arguing how important it was to own to own the terminal equipment, the telephone, because they didn't own the telephone. If someone had a problem with his service, he wouldn't blame his telephone that he had bought. He'd blame AT&T, and then be so difficult to figure out who was responsible and all this. And I remember saying to these people, look, you know, the logic of your position is that companies that manufacture a television set shouldn't sell the television set. They should lease it, so that if there's any complaint about, you know, how it's working, they can, you know, they control it, and they don't let you own it, so you don't screw around with it, and so on and so forth. Or I said, you know, clothing stores should just lease you your clothing, so if you lose a button or something like that, they can make you return it. And this guy and these people said, yeah, well, they didn't, not with the clothes. They realized there was something wrong about the clothing example. With television, said, yeah, it'd be a good idea. I should sell television sets, should lease them. So that mindset. So AT&T was a company, was controlled by engineers who were contemptuous of consumers. They didn't understand why anybody would like a colored telephone rather than a black telephone. They couldn't understand that. And they just didn't accept that. They were going to. They knew it was good for consumers. They were going to do it. So that was part of. The other part was their political part. They were playing a political game, which consisted of every year, because there were very rapid technological improvements in telephone in the telecommunications industry, for which AT&T bore a great deal of the responsibility to their, you know, with Bell Labs and so on. And so every year the costs of telephone service dropped, and AT&T would reduce its rates, and the FCC would be very happy. So there's no real regulation. No one was really asking whether they could have reduced their rates more. It was a big rate reduction, voluntary. Commission would take credit, wouldn't have to litigate with them, and they kept the local rates down very low, because they felt that if local telephone service was very cheap, that would give them tremendous political support, and no one would try to screw around with their monopoly. So it was a very good, you know, this engineering political business model was very effective for many years, but with technological innovation, it eventually collapsed. So that was all to the good.
While you were at Stanford, you published an article, Oligopoly in the Antitrust Laws, a Suggested Approach. And that basic approach is also found in your 1976 book, Antitrust Law and Economic Perspective, and in your 2000 edition of Antitrust Law. And in the preface to your 2001 edition of Antitrust Law, you stated that your ideas on antitrust law continue to bear the stamp of Aaron Director and the late George Stigler, and that it was your pleasure as well as your duty to acknowledge once again your profound intellectual debts to both these great economists. Could you tell us more about these profound intellectual debts to these great economists, how they shaped Chicago school analysis, and how they shaped your thinking in particular?
Well, when I was in the Solicitor General's office, I had read a book by another Stanford professor, Herbert Packard, called The State of Research in Antitrust Law. Really more a pamphlet. It was very good. It was very interesting. And he mentioned this Chicago School of Antitrust Analysis, and he treated it as a kind of interesting heresy, or, you know, interesting weirdos. He was skeptical, but he was respectful because he thought they were interesting. And he particularly mentioned Aaron Director. I never knew who Aaron Director was except for the Herbert Packard's book. When I started teaching at Stanford in summer of 1968, I just walking to my office, or walking through the corridors of the law school, I noticed there was a door with the doors had frosted window panes, and there was a name, Aaron Director, and there was a light on inside. So having heard the name Aaron Director, I just knocked, I introduced myself, and we became friends. And he was very, very smart. I was very impressed. And he, really opened my eyes to a completely different way of looking at antitrust, and I found it very persuasive. And I wrote this paper. I wanted him to, sign on as a co-author. Not that he'd done any of the writing, but, the ideas were mostly his. But he was a very modest person. He refused. And then the winter quarter, just by coincidence, my whole involvement in antitrust is a series of coincidences. George Stigler was visiting Stanford just for the winter quarter. And George and Aaron was his best friend and sort of his only friend at Stanford. So he spent all his time with Aaron and therefore with me, because I spent a lot of time with Aaron, having lunch and so on. So I became very friendly with George, and he was brilliant person. I was really snowed by these guys. After Nixon was elected in November '68, he, as president-elect, formed a bunch of transitional committees. And one of them was an antitrust committee, and he asked George to be a member of it, to be the chairman. And I hadn't met Stigler at that point. I don't think I'd met him. I'm sure I didn't meet him. But he asked me to be on the committee, and I'm sure that was Aaron Director's suggestion. So that's when I met him, Ronald Coase, who was on the committee, and others. And then Stigler came the winter quarter. So I got to know him very well. And then I think because I'd been on the committee, I'd met also a couple of law professors. Then I was invited to give a talk at Chicago, University of Chicago Law School.
There's reference to an industrial organization workshop in that.
Yeah, well, I was Stigler's workshop, and that's what I was, and that's so he asked me to give a talk, probably this paper you mentioned on oligopoly, in the spring of '69. And then they offered me a job. I wasn't asking for it. They just sprung it on me. But by then I realized, that although I liked Stanford, I liked Bill Baxter a lot, very able person. But I liked Aaron a lot. But Aaron was actually visiting Chicago 1 quarter a year still, and we taught antitrust together in fall of '69. But Chicago seemed like the real heartland of the economic approach to law. And it wasn't just antitrust, because at Stanford, Bill Baxter had a little reading group of faculty, which I was part of. And one of the articles we read was an article by Guido Calabresi on tort law. And I had no idea. Well, I had a little inkling, because I'd read Ronald Coase's article, Problem of Social Cost, when I was on the telecommunications task force. So I had an inkling that economics could be applied to other areas of law, but the Calabresi article made it clear that this was so, and it was very interesting. So going to Chicago was not just an interest in antitrust, but also, that's where Ronald Coase taught and so on. And it was known to be the school that had the greatest interest in economic approach to law.
Are there any others who have had a significant impact on development of your Chicago school views?
Well, certainly Coase, and there was another economist on the U of C Law School faculty, Harold Demsetz, who had written about property rights and about public utility regulation. And he was, I learned from him. And of course Milton Friedman was at Chicago. I never had too much dealings with him, and he left shortly afterwards for Hoover. And then
had you met Gary Becker at this time?
Well, I actually met Gary Becker at the dinner that Nixon held for the members of his various transition committees, because Becker was on the one dealing with education. And then he came and visited Chicago shortly after I came, maybe 1970 or so. And then he stayed on. So we became close friends, and he opened up other areas of economics to me, which had applications to law, some of which he had made, because he'd done himself. He wrote an article, published an article in 1968 on the economics of crime and punishment. So that was an important article. So, but Bill Baxter also had written an article about airplane noise and about patent law, and he was very, very smart, very good economist, as well as lawyer. So, and there was, people like Calabrese, who I didn't know personally, but of course I met him eventually, but who published stuff. But for antitrust, it was mainly Stigler and Direct, although there were others, Lester Telser, professor at University of Chicago.
Back to oligopoly and the antitrust laws. In the Stanford article, you question the then prevailing view that monopoly pricing by oligopolists, when unaccompanied by any detectable acts of collusion, constitutes an economically and legally distinct problem requiring new doctrines and new remedies for its solution. You instead argue that both forms of collusion, explicit and tacit, can be proceeded against under Section 1 of the Sherman Act as conspiracies in restraint of trade. Have you seen use of your approach in the Antitrust Division's selection and prosecution of price-fixing conspiracies? And more generally, do you believe that the approach in the article has affected development of the law relating to horizontal price-fixing?
I do think the Antitrust Division, the FTC, use this type of analysis in deciding what cases to bring, and also make some use of it in presenting evidence in cases. So, for example, the what's that? I forget which one. Is it Home Depot or
Staples.
is it Staple? Or there are these three things. Office Depot. So that's a case in which the FTC tried to determine empirically what difference it makes whether you have two or three, superstore competitors in a town, in a market. It hasn't received a great deal of attention from the courts.
Do you see
so my fructose case obviously takes that approach, right. But the cases I read when I was writing that opinion, I didn't think were very sympathetic. But it all traces back to something that Aaron Director had said. The germ of the idea was that he thought it odd that the lawyers were so preoccupied with proof of conspiracy rather than being interested in the actual economic consequences. That's what made me think, well, maybe the focus of a price-fixing case should be on the economic consequences rather than on the question whether there was actual communication among the competing firms. So, it's difficult. Don Turner had written an influential article saying that, in effect, you could never. His idea was you could never make tacit collusion a basis for an antitrust violation because a firm couldn't help itself in tacitly colluding. That is, if a competitor raised price, would be irrational not to raise your price also. That, I think, was exaggerated, but he was right. Very difficult to prove a case when you don't have the smoking gun type of conspiracy evidence, when you're just inferring a conspiracy from behavior that is anomalous if the firms are competing. That's the essential approach. So I think it's an approach has promise. I can't say it's really caught on, but I think
the Supreme Court's decision in Bell Atlantic versus Twombly affects its viability.
No. My interpretation of the Twombly case is that if you allow an antitrust plaintiff in a big antitrust case, if you allow an antitrust plaintiff to surmount a motion to dismiss with vague, unsubstantiated allegations of collusive behavior or exclusionary behavior, then you tend to force a settlement, because if a plaintiff resists a motion to successfully resists a motion to dismiss, the next thing is discovery. And of course, discovery very, very costly in a big case, not just antitrust case, but any big case. And at that point, the defendant has to decide, is it really worth fighting this, or should we settle? So what the court, I think, was trying to do was saying, we're going to make it easier to file a motion to dismiss in a big case, because we're going to require more detailed pleading. And now when you put this together with the Matsushita case says to resist, I think that was summary judgment, but to get to a trial, or to keep your case alive, you have to, not just enough to have a theory, you have to have something that makes some, at least minimal economic sense. So if you put that together with the rule of basically of fact pleading in Bell Atlantic, you see that a plaintiff in a big antitrust case has to do a lot of work in order to get to the discovery stage. That's perfectly sensible. But I don't think that affects the underlying theory of, tacit collusion. And even in the fructose case, it wasn't just tacit collusion. There was some other evidence. So I think in a case like that, as long as the plaintiff can set forth some specific, economic phenomena in the market that are indicative of collusion, I think that's enough to survive. But the courts don't seem terribly friendly. I say, when I did the fructose research, the courts seemed pretty quick to get rid of cases which didn't have sort of good smoking gun evidence.
Much has been written about the impact of the Chicago School of Antitrust Analysis on antitrust law. Could you briefly describe for us what is the essence of the Chicago School approach and what you view as its basic tenets?
Well, you have to understand it as a reaction to the Harvard School of Workable Competition, which was it tended to be non-theoretical and non-empirical, but rather speculative and impressionistic, and suffused with an assumption that monopolistic or anti-competitive behavior was extremely common and was a sort of natural explanatory factor in otherwise inexplicable business behavior. So the Chicago economists, of whom Aaron Director was probably the central figure, said, well, the way to look at it is don't assume that a practice is monopolistic, see what is the explanation that best comports with the assumption that the defendant is a rational maximizer of profit maximizer. And that, so you have, simple theory of rational economic behavior, and sometimes there'll be a monopoly explanation, and not, but you want to compare, you want to look at the behavior that's claimed to be monopolistic and ask, is monopoly the best explanation, or is there other explanation more compatible with rational self-interest? So this was applied, for example, to tying agreements. So there were these funny old cases. Company sells salt machinery for processing salt, and says, we have to buy your raw salt from us. And so the Harvard approach was, well, that must mean that you're using your patent or some other source of monopoly power over the machinery to try to get another monopoly, a monopoly in salt. So Aaron, director, pointed out that didn't make sense, because if you monopolize an essential input, then you can earn all your monopoly profits that way, and it won't do you any good to have a monopoly of another input. So he looked around for other explanation. The explanation came to mind was not that this was a way of annexing another market, but it was a way of price discrimination. So the people who used the most salt with their salt machinery were the ones who were getting the most benefit from it. So if instead of charging them a high price for the salt machinery, you charge them a high price for the salt, maybe you could give away the salt machinery, just charge for the salt. You'd be automatically charging the big users more, and that would be a way to maximize your profits. But it wouldn't be a matter of becoming a seller, a monopolist of salt. You just wanted to reprice the salt, but whoever was selling salt, you wouldn't want to take over and run their business for them. So that was one example. Another was resale price maintenance. So the Supreme Court had said, 1911, that for a manufacturer to set a floor under the resale price of his good, that's the same as if the retailers got together and agreed to fix their prices, which would be price fixing. And then the Chicago people pointed out that didn't make any sense, because why would a manufacturer tolerate his retailers? Why would a manufacturer, by setting a floor under his retailer's resale price, or wholesaler's retail, whatever, any distributor's retail price, by doing that, he just is going to reduce the demand for his good, because distribution is an input into production. So if you're producing toothpaste or something, you want the cost of distributing the toothpaste to be as low as possible, not high. And then but nevertheless, setting floors under your distributor's price, resale price maintenance, was very common when permitted, so there must be another explanation. The explanation, or there are several. One is that, well, what you're trying to do is you actually want your retailers to compete with each other, but you want them to compete in providing services, point of sale services. That's easy to see with automobiles than with toothpaste. You want the dealer to have a nice dealership and learn a lot about the product, spend time with customers and so on. To do that, you have to give them an additional margin so they can to finance that activity. Now this kind of thinking has been absorbed. It's no longer a school of thought. It's the way pretty much everybody thinks. There are still differences in how people react, or economists or lawyers react to particular, or judges to particular cases. But this principle that you're trying to find the explanation for behavior that's most consistent with the assuming rational self-interest on the part of the business people, that's quite orthodox.
In 1979, did you believe it was inevitable that the Chicago School of Analysis would affect changes in the law that in fact did occur in subsequent years?
Well, I don't remember the article, but I think I was probably talking more about academic thinking about than the courts. Yeah.
You wrote in 2001 that even with the degree of consensus about the goals of antitrust law and the essential tenets of economic theory that should be applied in evaluating specific business practices, that there is much room for debate over specific practices, cases, and rules. Could you identify for us some of the specific practices, cases, and rules that you might have in mind over which there is still much room for debate?
Yeah, well, whenever you have a practice that has good and bad effects, you're going to have a difficult judgment to make. So an example is loyalty rebates. You give a rebate to a customer who buys a lot from you, and of course that deters him from buying as much from your competitors. So it can be exclusionary. It can have an effect of excluding an equally efficient competitor. On the other hand, of course, there are obvious benefits to customers in being loyal customers, right? They're treated better. And their information costs, their search costs are reduced. So it's very hard actually to balance costs and benefits of competitive behavior, or allegedly anti-competitive behavior, because you have to do empirical work, and that may strain the comprehension of judges or jurors. But a lot of progress has been made. In the 70s, with a couple of other guys, I started a consulting firm or lexicon for providing economic support in litigation. And I wasn't the first such firm, but I think it raised the level of sophistication of economic support in litigation, and a lot of high-quality empirical work is done in these cases. So I think it's becoming easier, more feasible to make these judgments. But whenever there's uncertainty, the response of the enforcement agencies and the courts and so on is going to be shaped by, kind of preconceptions that judges bring to cases. Do they like business, not like business, so on? Do they like economics?
Do you have more confidence in the ability of the judicial system to evaluate and compare the anti-competitive effects of a practice versus the pro-competitive justifications for it?
Yeah, I think that may well be true. I'm not sure exactly what's left of the Chicago School. As I say, there's much more consensus than there used to be. I don't know who identifies himself or herself as Chicago School antitrust economists, but there are clearly people who are more skeptical of judicial capabilities than I am. But I think I think a case like Twombly is fine. Yeah, you want to make the lawyers really think before they put a defendant to the expense of defending an antitrust suit.
Recognizing that there seems to be a convergence of thought. I want to go back for a moment to 1979 when you wrote that your views closely resemble but are not identical to the more orthodox Chicago position espoused by Judge Bork. In what ways then did you differ from his views, and do you think those differences still remain?
Yeah, I don't remember what I was thinking then, but later on, in the second edition of my antitrust book, the 2001 that you mentioned, yeah, I did take issue with him over such things as the standard fashions case. Although actually I was really parroting an analysis of the case by Aaron Director and Edward Levy back in the 50s, one of the very few articles that Director wrote. So that's the case where the Standard Fashion Company was requiring its dealers to carry the full Standard Fashion line of, these were patterns that women would buy and make a dress from them. So it was really intellectual property. And the concern was that Director and Levy had mentioned that I was persuaded by and repeated was that if a dealer had to buy the full line from Standard Fashion, if the full line was bundled, how would a new entrant who wasn't prepared to do the full line but just wanted to do one pattern, one size or something like that, how would he get in? He'd have to produce the full line. And it's the issue that recurred, with Microsoft, with the operating system. The operating system is a bundle. The Windows system is a bundle of almost 30 separate programs. And of course, you buy the bundle, you don't pay anything extra for anything in the bundle. So what if some company had some terrific spell check and wanted to, break in with its spell check, but unless the spell check is, vastly superior to the spell check in Windows, why would a customer or a consumer, why would it pay extra for a spell check when it already has an adequate spell check? So I think bundling presents, legitimate issues of antitrust, whereas Bork, my impression of it, doesn't buy any of that, doesn't think that any exclusionary practice is sufficiently common or sufficiently harmful to warrant antitrust. So I think he would just limit antitrust to cartel enforcement, or anti-cartel, or maybe large horizontal mergers, but I don't remember.
There has been development over the last few years of what are known as post-Chicago analytical approaches. One of those post-Chicago doctrines involves the unilateral effects theory relating to mergers, and I don't believe I've seen any of your writings refer to unilateral effects theory. What are your views on unilateral effects theory for analyzing mergers?
Well, that just sounds like...
sort of like the Staples deal has been sort of called one variation in that. Does that resonate at all with anything?
Well, if you have competitors in selling a differentiated product, then each of them has a little tiny bit of monopoly power because there's no perfect substitute. So there's some group of customers that prefer a particular brand, and if if two of these are particularly good substitutes for each other and nothing else in the market, although we're calling it one market, is as good a substitute, then yeah, if these two merge, they'll have a little more freedom from price competition. And that just sounds like a refinement of the ordinary concern with mergers to monopoly, right? You're saying two firms, we're calling them part of a larger market, but actually they don't have any perfect substitutes. So they're really their own little market. Only the two of them are selling the identical product. So if they merge, that gives them a monopoly. Not a strong monopoly because they're good substitutes but not perfect ones. But that doesn't sound like an analytical novelty.
In the world situation, we now have over 100 competition agencies with varying competition rules, including the European Union and now even China and India. What is your assessment of competition law policy and enforcement outside the United States? Do you like what you see?
Well, not much. I know a little about the enforcement by the European Competition Commission, European Union Commission. And I mean, clearly they have a more kind of old-fashioned view of antitrust as something that's designed not just to maximize efficiency, but to protect firms that are at a disadvantage because they're small. So I mean, one big difference, maybe it's eroded, and I haven't followed this closely, but so we understand that a large firm is free to use the same competitive tactics as its small competitors, with very rare exceptions. But the Europeans think that if a firm has 30% of the market or something like that, then it really can't. It really competes with the others. It has to compete with the others with one of its hands tied behind its back. And it's clearly more than difference over economics. It's part of a general European anxiety about too rapid economic change and a more protectionist a view of business and a greater risk aversion. So that's a major difference.
Could you give us your views on the multiple enforcer system we have in the United States with two federal agencies, state's attorney general, and private plaintiffs who can bring class actions? Something
you mentioned earlier that was in the 2001 edition of my book on antitrust. The real problems in antitrust are less ones of doctrine than ones of enforcement procedure, the institutional structure. So it is cumbersome to have the Justice Department and the FTC and the state attorneys general and private parties all in a position to pounce. So that does seem unduly cumbersome. Now the FTC and the Justice Department, they divide up the antitrust business, so that isn't such a problem. But the states, of course, can pile on, as they did in the Microsoft case, and then the private plaintiffs come along. So that's cumbersome.
You have pretty strong views about whether the states ought to be in the business of antitrust enforcement, isn't that correct?
Yeah, I don't think they should be. It's partly my experience as trying to mediate the Microsoft case, where I thought there were like 16 states at one point that were plaintiffs, and they didn't play a constructive role, partly because they have very little staff, and partly because in, I think, all the states, the Attorney General is a official who is elected apart from the governor. He's not part of the governor's administration. And so he's his own political animal, but also because he's not part of the governor's administration, he finds it difficult often to get adequate funding from the legislature. So most of these state attorneys general are very understaffed, and of course their responsibilities go far beyond antitrust. So I think they tend to play a rather mischievous role. And, you know, they say about it, state attorneys general, they're all governors in waiting, and that their enforcement actions are politicized to a great degree.
Did you do any analysis, though, beyond, is your analysis based on anything beyond the Microsoft case? I mean, have you done any studies of this area?
No.
You've taught antitrust, and we're not going to have a lot of time to talk about it, but I am interested in, and I think people will be interested in knowing your approach to teaching antitrust and whether it's changed over the years.
Well, I haven't taught antitrust for probably 30 years.
Okay.
So I don't have any. Yeah, I think the late 70s would be the end of when I taught antitrust, so I don't have any. But when I did teach it, so I had a case book on antitrust. It was very much focused on economic analysis of antitrust, as I think all courses are now, because goals of antitrust other than economic efficiency have pretty much vanished from the American antitrust scene. So if you're teaching antitrust, you're teaching economic policy. And of course, there are some interesting cases, but I say it's an economic saturated field, and it has to be taught that way.
We have focused today on your antitrust writings and your antitrust scholarship. Of course, you've written many books and articles, not only on antitrust, but on law and economics more generally, on political issues, and on jurisprudential subjects. Of all of your books, which did you enjoy writing most?
I always enjoy writing a book because I mean, I'm not compelled to write books, obviously, so if I write it, it's because I look forward to enjoying doing it. So I wouldn't want to pick and choose, you don't want to, it's like playing favorites among your kids, right? We're not allowed to do that, so similarly with books.
Judge Posner, among the many decisions you have written in the antitrust area, which ones do you believe are the most significant, and why?
No, I have not had a lot of antitrust cases. So I had a couple of FTC merger cases in the 80s that I enjoyed, and I've had some vertical cases.
The high fructose case.
And the high fructose case, the almost tacit collusion case, I enjoyed that a lot, working on that. But that's relatively recent, which may be why I remember it. And I think I've just forgot. I had another interesting horizontal case involving paving materials, road material. Yeah, that was a fun case. I liked that. And I'm sure I've had other dealing with sort of peripheral issues, enforcement issues, sentencing. And I've written a lot of cases dealing with class actions, which have a significant bearing on antitrust, even if they're not class action. They're not antitrust class actions, but no, antitrust really hasn't been a major area of of cases free. I could mention a whole list of fields in which I've written a lot more opinions than in and what I would regard as major opinions than in antitrust.
You've been a judge on a very distinguished court of appeals for a number of years. Do you have any comments or suggestions you can make about the art of advocacy? What do you as a judge most like and most dislike about the oral advocacy styles you hear every day?
Well, the single worst thing that lawyers do in advocacy is remain at the semantic level of issues and try to club the judges with verbal formulas taken from cases. And that's really useless. And the best thing they do is when they really understand the facts and the background and they understand the transaction that they're litigating, really understand the transaction, why it was structured the way it was, and what the consequences would be of deciding a case one way or the other. But instead, they like to get up, and if there's some formula that has been recited in a number of cases, they will run with that, and then they'll get up and they'll try to argue, this case is governed by another case, and they try to explain it. I've said to them, don't tell us about cases. In a civil case would rarely reach the oral argument stage in an appeal if it were actually governed by another case. So they ought to tell us, what is really going on here, and what would be a reasonable result, a practical result, but within the framework created by governing cases and statutory text and the like. In the case of antitrust, no one really pays any attention to the statutory texts, and the decisions tend to be, opinions contain useful guidance, but they don't decide the current case. So the more concrete the lawyers can be, the more effective. And I don't think this is an idiosyncratic response, because when the judges confer after the arguments, if there's been a good lawyer, one of the judges will say, I really liked X, or if there was an atrocious lawyer, say that lawyer was terrible. And invariably, the judges agree on who are the good lawyers and who are the bad lawyers. So it's not that most of them wouldn't be as blunt as I'm being about what we're looking for, but I think the reactions are very, very uniform. The judges want to decide the case in a reasonable way. I mean, they may have preconceptions what is reasonable, but they want to do it in a reasonable way, and they don't want to be trapped by verbal formulas. And if they think the lawyers are, giving them a real sense of what's at stake and so on, they really like that. Of course, if the lawyers seem to be honest people, that makes a big impression. So as I say, I don't think there's much mystery or much divergence among judges in what they're looking for, but we, the judges, are terrible at conveying to the lawyers what we want, because the judges don't think it's their job to improve advocacy. And maybe we should. They just don't think of it that way. They just sit there and listen to the lawyers. And sometimes, we get impatient with the lawyers, but we don't engage in some systematic education in how to present case on appeal. It should be obvious, actually, but it doesn't seem to be.
Judge Posner, thank you very much for your time this afternoon and sharing with us your experience in antitrust and your many insights.
Pleasure has been mine. Thank you for your excellent questions.